Good afternoon, everybody, and welcome to our weekly meeting of the Public Safety and Homeland Security Committee. Before we get started here, I'd like to ask Representative Green, who ought to be very thankful just getting out of the hospital the last day or two, to ask a blessing.
Let us pray. Let us pray. Let us pray again. Our dear Heavenly Father, we just thank you for this day. And as we give you the honor and the glory, may we realize the greatness of thou powers and what you're able to do for us each and every day. And Lord, we just ask you now to be with each and every individual that is here to do the work of the state, and that we will deliberate and make the right decisions. And we ask all of these things in thy holy name. Amen.
Okay, we got a busy schedule today. I think we got 7 bills on here, and I have. Do what? You don't have all these?
I don't have that one.
Well, maybe we don't have 7. I got 7 on my list, but 1, 2, 3, 4. Okay, apparently we only have 4. I don't know. She just printed it off for me. We'll go ahead with what we got and see what turns up. But I'm going to call them a little bit out of order. First up, we're going to call House Bill 903 with Chairman Dollar. He's got a committee he has to chair in half an hour, so I want to get him out of here so he can do it. Has everybody signed up that wants to speak to a bill? Have we done that? We only got 4, so anybody else wants to sign up, now's your opportunity. Okay, Chairman Dollar. You're on.
Thank you, Chairman. 903 is a simple bill. It's identical to a bill that this committee passed out last year and was passed out by the House Bill 342. And what it states is that if a vehicle is pulled over for a vehicle infraction, meaning problem with a tag, tail light out, things of this nature, this will give law enforcement the ability to ticket the owner of the vehicle if they're in the car, but they're not driving the car. Currently, the ticket must be issued to the driver, and this does not mandate that they have to do it. It just simply empowers them and authorizes them that they may do it.
Okay, that's just to double check. That's LC 412225.
I believe so, Chairman.
Okay. Do we have any questions? 21.
No double jeopardy, though. Is that correct?
No, sir.
So you can't issue the citation to the driver and to the owner of the vehicle.
Oh, no.
Any other questions from the committee? No questions.
I'm amenable to an amendment that requires a sky bridge or a tunnel between the Capitol and the LOB. That'd be a friendly amendment.
Well, back when I was the Homeland Security Director, that was something that was offered, and
Yes,
for a couple of reasons. And I think I came up with 28 different things they ought to do to Capitol to tighten up security. But because of the structure and how imposing it is, and they didn't want to change the decor and run a tunnel above ground. It'd have to go underground. That was pretty much a more difficult But anyway, I'm open to somebody who wants to make a motion. We have a motion to pass, and we have a motion and a second. Any further discussion? If not, I assume we're ready to vote. And all in favor signify by saying aye. Aye. All opposed? Off the rules.
Thank you, Chairman.
Next is House Resolution 1160. Representative Buckner.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, the area of the state that I live in has the intersection not only of the North and South Railroads, which is where Junction City gets its name, but it also has the intersection of several highways, Highway 96, US 80, and 19. And we have a lot of trucks that are coming out of Savannah headed towards Alabama. We have a lot of trucks that are large trucks that are going from the inland port in Cordele up towards Tennessee, South Carolina, and Atlanta, and other places. And so I have received over the course of a number of years some complaints about the public safety inspections that are done on the sides of the road. It's not that they mind the inspections, they just don't think that it looks very safe for it to be done on the side of the road. Some of the big container trucks also, while they're sitting there and that inspection's going on, they are on the clock, literally, and they are detained, and then they many times, if it takes a while for the inspection, they will have to pull off the road a little further down the way, and it'll put them behind schedule. What we wanted to do was look at some of the issues with these inspections, look at the fact that they can be pulled over for an inspection of this type repeatedly and as often as they are seen on the road. We wanted to look and see if there is a way that we can help the public safety department do what they need to do, but do it in a place like maybe at a weigh station or at the company's yard where the trucks can be inspected while they're not on the clock. They would still be able to pull over vehicles that are obviously operating and have an issue. That would still happen, but the actual inspections of the trucks would be done in a safer environment and would be better for the business model to be able to meet their trucking deadlines. So it's a study committee. We're asking people of the industry and people that drive trucks and people that of all different types that they could get together and we could have a conversation and see if there's a way that we can do what we need to do, but maybe in a better fashion.
Do we have any questions for the author? Number 14.
Yes, thank you, Rep. Buckner. So right now, are they being inspected at a weigh station off the side of the road? Is that where they're?
There are a few instances where the inspections are taking place, like in the yard, where if it's a large trucking company and they have a lot of trucks, they will go to the company and do them there. But what we're seeing in our area is that a lot of times they are done right there on the side of the road, and sometimes it's perceived by the people passing by that when they see Department of Public Safety, it just doesn't look very safe that they would be being done on the side of the road.
Number 27.
Thank you, Mr. Chairman, author of the bill. And I understand what you're trying to do, but I wonder whether it's really necessary. Right now, when the Motor Carrier Division pulls a truck over, they have a specific reason, and that reason might be consideration of brakes or lights or any number of things that's required. And right now, they can order a truck to go up to the nearest weigh station if they're within close proximity. If they're not in proximity to that weight station, which there's not that many weight stations out there, then that's where they have to do it, because a lot of times if they've got just reason to pull over a motor carrier, it's because that motor carrier possibly needs to be written out of order because of brakes or because of something else that's dangerous. I mean, I just want to clarify that you understand that.
Well, I do understand that, but it's also a question by the people that are in the business that there are an awful lot of inspections that go on repeatedly to the same trucks. That it might be, and it's my understanding that in order for us to get the federal DOT dollars, that they have a quota of how many inspections they need to do. But it just seems to me that we could work together and come up with a plan to help all of those needs be met in a safe manner. And we could they still need to be on the highway and do inspections for things that they see are wrong. And we need to look at the funding for that department and see if the training of the new trailers and trucks that are out there is adequate, or do we need to make a recommendation that they need additional training? Because there have been some questions about that as well. There have been people that have been pulled over and said that something was wrong with the truck, and it's a whole new model of trailer or truck or stabilizer bar that was supposed to have flex in it, and they wrote them up for having a flexible stabilizer bar, and it's supposed to, and they thought it was supposed to be rigid, and it wasn't. So there are some training issues that we thought we could just look at it in the study committee and see if there's any way we can improve this program, not just for safety, but also for business.
I tend to agree, possibly for no other purpose than knowing in the budget how much motor carrier division was cut in the recent budget and the supplemental budget. That I have concerns is going to impact the training of a lot of those. That might be a perfect purpose of this resolution.
Thank you.
Any other questions? We've got one person here to speak to it. If there are no further questions, Major Vicky with the Georgia Department of Public Safety.
Thank you, Mr. Chairman, committee members. The resolution, the way it was written up, it kind of be detrimental to our commercial motor vehicle safety program. We're fourth in the nation in fatal crashes when it comes to commercial motor vehicles. So our number one function is to actually reduce those fatal crashes. Over the last 4 years, through data and analytics, it showed that the number one causation for commercial vehicle accidents is actually driver behavior. We can't observe that behavior if we got our officers setting up in an inspection station somewhere on the side of the interstate. 68% of our crashes are happening on our state routes, not our interstate systems. So we need our officers on the state route systems, not necessarily tied up at an inspection station. There's a need for the inspection station. We do level 1 inspection, which a level 1 inspection is pretty much a full inspection where they crawl under the truck. We have pit areas for officers to do that in certain cases. But there's times on the side of the road when they may see a brake out of adjustment, or they're going to be turn signals in the rear, or a log truck without a flashing light on the rear, that they need to be stopped and inspected at that point. If we had some more safer locations on our state route systems, maybe some places to pull over the trucks in the safer locations, that would help. But when our main concern is the fatalities that's going on in our state, we have actually made a 10% reduction in fatal crashes last year. And I bring that to your attention because it's our focus to reduce those crashes. So, and that's happened. So, I just don't think that this is the answer of putting our guys at inspection stations all the time and not having that roadside type inspection. Visibility is key. When our officers are out there, crashes tend to go down. We've done some analytics on that. Just for instance, in our hurricane seasons, when our guys all of our resources are tasked to go help people on the coast, we've seen an increase in crashes because our resources are pulled from their respective regions. So having that visibility out there really deters people from doing wrong. So just kind of want to give you our insight on what we do and how we do it. If y'all have any questions for me, I'll be glad to answer.
And correct me if I'm wrong, but one of the reasons that so many trucks get inspected repeatedly is that they work in one certain area, and the federal government identifies certain areas that have an abundance of crashes, and they require your people to be in that area.
Yes, sir, Mr. Chairman, they do. It's actually called our high crash corridors, and our captains have an analytic program, and actually they see where these crashes are happening each and every month. This data is fairly recent. It's not really historical to like it used to be. So yes, we're looking exactly where the crashes are happening. That's where we're putting our resources. That's where our officers are working. So yes,
so if the same trucks come through there repeatedly, their odds of getting stopped are greatly enhanced.
Yes, sir. And the thing is, though, if they're operating safe trucks, we give them CVSA decals. That's kind of an attaboy sticker. It's good for 90 days hereabout. So if they get one of those stickers on their trucks, our officers are to actually recognize that sticker and let them go on down the road. So there's ways to see. They'll check previous inspections through our system in the car. So if they've been inspected, we try not to hold them up and get them on down the road.
But the process for that is that you work with the company that employs them, and you go to their facility and inspect their trucks. Isn't that correct?
Well, sometimes we could do that, sir, but a lot of times it's just regulatory random. The feds really don't like for us to go in and actually inspect them at the facility. They want us to catch them on the roadside. They really don't want them having an opportunity to know we're coming to fix all their problems. So we want to catch that roadside.
And pretty much motor carrier is a federal operation. It's greatly subsidized by the federal government's money.
Yes, sir. If we're required to have 2 means of weighing trucks, You've got your static scales and your portable scales. If we was to take the portable scales away that are in our cars, then that, yes, that could actually affect the federal funding with federal highway.
You want to
Yes.
go ahead?
The intent of the whole issue is the fact that the number of complaints that I have received and heard other legislators say that they have received is that there is a disconnect of what the purpose of the department is and what the actual function of what's happening beside the road and the appearance of what happens beside the road. If for no other reason, making sure that we are doing everything the way it needs to be done in order to get the federal funds and to ensure safety, I'm thinking that a study committee is a way for us to share that information. If there's always, usually there's always room for improvement, and this would give us an opportunity to see if there's any way. I'm not about undoing the great you've done to improve safety, but I also know that there are some people out there that don't understand what the whole purpose of the program is, and honestly feel like they are victims of a process that they may not understand and may not appreciate.
Yes, ma'am, I understand that too, but we also have a big part of our program is education and outreach. They have the opportunity to reach out to me. We love to go into carriers. We like to talk to them. We like to educate them on the rules and regulations that we enforce. We encourage any motor carrier to call us, and we'll go in, we'll spend a day with them. We'll do mock inspections on their truck. We'll show them exactly what they need to have working on their truck before they get on the roadway. We'd rather actually get them before they get on the highway. We tell everybody that. So that's a big part of it. The disconnect a lot of times is when the complaints come in, I offer my services to educate the folks and have our guys go in, but rarely do I get that call that they want to hear what they can do to make themselves better. So that's the problem I run into. But it's there. And I mean, I agree with you. If we can meet and come up with a resolution, that's fine. But we do offer the education outreach. Matter of fact, we're going to Moultrie this coming week to meet with the farmers because they operate under a little different rules than everybody else. So we want to meet with them. They've got some questions, and we hope we can help them out later on this week.
Number 21.
Major, thank you for what y'all do. I have found it very interesting that on your social media pages, you share some of the violations that you see out there on the road.
Yes, sir. That's very popular.
It blows my mind, some of the crap people want to drive up and down the road with 20,000 pounds or 500 pounds or 1,500 pounds.
Yes, sir.
Unbelievable.
Yes, sir. That has been one of our success stories is the violation of the week, we call it. When our guys actually see something that's detrimental out on the roadside, they'll take that photo and we'll share it to the public.
That's a ticking time bomb.
Yes, sir.
Thank you for what you do.
Thank you.
Number 17.
Thank you, Mr. Chairman. My question is, I drove up from Augusta this morning, and I actually saw two 18-wheelers that were pulled over. And it's very, very dangerous when you have to go, we have to move over. Yes, but when you can't move over, yes, it's very dangerous. And I was really, really nervous even coming up on that because I couldn't get over. Yes. And then the truck is on that easement, and it's twice as big as the easement. Yes. So, and I saw two trucks. So can you tell me what is the percentage of trucks that are normally pulled over? And I know you might not have an answer for this, but I'm just looking at the manpower. That was 2 officers in a 3-hour period. Yes, ma'am. So what is it that will impede them from taking care of that and then getting right back out on the highway and taking care of us?
Well, number one, I mean, what we try to do is the way we teach our officers. We try to make them be familiar, like especially on the interstate system, where they're at. So a lot of times we'll try to actually activate our blue lights where that truck will get off the next exit. But a lot of times the driver, he just sees blue lights, so he's going to pull over immediately because he don't want to think he's running from us. So, but a lot of times, even on our outreaches, we try to tell them, hey, slow down, put your blinkers on, let us know that you're going to find yourself a safe location. We try to do it that way as far as getting them. But, I mean, we don't have any control. Once we light them up, if they pull over, we try to then guide them to a safe location. And if you see in 2 or 3 of our officers, it's called our Stop the Threat program. A lot of times in those high crash areas that the chairman was talking about, we'll assign 2 to 3 people in that area at one time to actually observe driver behavior and try to get those unsafe drivers off the road.
Okay.
Number 14.
Yes, thank you. So your motor carrier compliance enforcement officers, so do they only do that, or do they do other public safety stuff too?
That's been the success of our program versus other states. they concentrate 100% on commercial motor vehicle safety in our state. So, yes, ma'am, that's our sole component. Now, we'll help out with Georgia State Patrol if there's a hurricane detail or something of that nature, or a protest, we'll help with that. But, yes, that's our main function.
Okay, so if someone were to, so they're pulled off the side of the road, but then if there's a speeder going by or something that's not this, one of these officers wouldn't go off to catch.
Ma'am, I'll be honest with you,
Yeah.
they are authorized to do that, and I mean, I do have officers from time to time, if they observe somebody doing something that's gonna hurt somebody, of course, they've got the authority to pull them over, and they do that seldomly, but it's not often. And when they do, they usually tell me what's going on with it, just because I like to concentrate on commercial motor vehicle safety in our division. That's what we're mandated to do.
Any further questions for either the author or the speaker? Okay. Do we have anybody who wants to make a motion about whether or not we're going to have a committee, a task force? You move. We have a motion do pass. And a second. And number 17 wants to ask a question. Oh, I'm sorry. Okay, we have a motion and a second. Any comments? Okay, we'll call the question. All in favor signify by saying aye. Aye. All opposed? Okay, motion carries.
Thank you.
Sure. And now, apparently, the one everybody's been waiting for, I hate to save it for last, is House Bill 641. Oh, you don't count. You're going to be here. You got to go? Eddie, can we hold on just a minute and let the chairman do his? He's got a real quick one here, sure. And he's got another meeting. Sure. Chairman Green.
Thank you, Mr. Chairman. I appreciate you letting me go ahead and on this. This is House Resolution 1008, and this is an urging resolution to the State Board of Pardons and Parole, and it deals with a young lady that was put to death, and her name was Susan Eberhardt. And this is to bring a little closure to the family that, as we have gone through and the research has pointed out about the evidence. And I'm just asking us to do this resolution to ask the Board of Pardons and Parole to look at it and see if they can come to an understanding about this and look at all the things that occurred in this trial. And that's what I'm just asking for, an urgent resolution here.
When did this occur?
In 1871, I believe.
That's what I thought.
1871. 61.
61?
61.
Does anybody have any questions for the author?
At the appropriate time.
Ma'am?
At the appropriate time.
Nope, there apparently are no questions, so this is the appropriate time.
I move to pass.
We have a motion to pass. Do we have a second? Second. And a second. Any further discussion? All in favor signify by saying aye. Aye. All opposed? Motion carries.
Thank y'all so much.
Okay, now to 641.
Afternoon, Mr. Chairman, members of the committee.
I know there have been a lot of amendments on this one, Chairman. Could you give us the LC number, make sure we all on the right one?
Right. Bringing to you House Bill 641, LC 41244-2S. This is a bill that's requested by the Georgia Bureau of Investigation, and this is a bill that deals with cyber crimes and the GBI's authority to investigate cyber crimes. All of us are aware that technology is changing the world we live in very rapidly. A lot of the laws that we have on the books, the things that we have to deal with, do not always reflect accurately what needs to be taking place in regard to that. So the bill before you today is intended to give the clear legal direction for the GBI to be able to investigate things that deal with cyber crimes subject to the Georgia Computer System Protection Act, which I believe was passed back in the 1990s. If you look at the bill, the first page is just the law as it starts today, but lines 35 and 36 begin to identify what the bill does, and Section 2 really lays out the things that are important about how the bill operates. I have with me today Deputy Director Dutton for the GBI, and with your permission, Mr. Chairman, I'll let him make some comments and explain to us walk us through the details of it.
Certainly. Be glad to hear from him.
Thank you, Chairman. So GBI's authority, we are primarily a request agency. There are a few crime codes that we do have original jurisdiction in. Cyber crimes is not one of those. An example of crimes that we do have jurisdiction in would be narcotics, child exploitation cases, elder abuse cases, which gives us the latitude to initiate an investigation without a formal request. The issue with cyber crimes is venue is a very difficult challenge to overcome. So with jurisdictional authority in investigating these crimes, would go a long way with moving that forward. The second part of this bill deals with subpoena authority as it relates to information needed to further an investigation of a cybercrime and the specific ones that are outlined in this bill. This is very similar to the current law as it relates to child exploitation cases, with the requirements that must be met from the standpoint of requesting a subpoena. The subpoena actually, the authorities for the subpoenas are actually through the Attorney General's office with approval from the Attorney General's office by the director, assistant director, or myself, deputy director for the agency. That's it in a nutshell.
Okay, we have any questions from the committee? Number 15.
Thank you, Mr. Chairman. A couple of questions. One is, what standard, if any, will there need to exist to issue a subpoena? Reasonable suspicion or just an investigation?
Well, it's more so reasonable suspicion. So these cases, specific as it relates to cybercrime and very similar to child exploitation cases, these become known to law enforcement through reporting in a myriad of ways. One could be through the federal system, as it reports anyone who feels like they've been a fraud through computer crimes can report that information. That information would come to us from that standpoint. So it's not at the level of probable cause, reasonable suspicion, and maybe a slight bit less than that. So it's a report of a crime.
Okay. And then in terms of what you can obtain from the provider, which looks like it's lines 50 to 61, as I read that, it's just whether or not you have service, who the service is with, telephone numbers. It's more identifying information as opposed to what somebody is actually doing online. Is that a fair reading?
That's absolutely correct.
Okay. And then my last question is on page 3. It starts with, and my understanding is that these subpoenas would probably be directed to like AT&T, Comcast, etc. But then this states, upon the failure of a person without lawful excuse to obey a subpoena, and then moving to line 65, such person may object to the subpoena on grounds that it fails to comply with this code section or violates any constitutional or other legal right or privilege of such person. Can you kind of explain that to me? Because I could understand the person for whom you're trying to receive information might want to implicate line 65 to 67 and wage an objection, but they're not going to receive notice, will they? Won't the subpoena only go to the telecommunications company
That's
and
correct.
not to the person?
That's correct. It would go to the company or the provider.
Okay. So can you think of any instances then where they would be raising these type of objections, a constitutional or other legal right or privilege?
Not necessarily with the individual, but the provider, yes.
How?
It happens, and the details of why they deny those or disclosure of any of the subpoenas, my special agent in charge with the Cyber Center may be able to address that more specific to a case that they've been involved with. But I do know that as the child exploitation unit moved forward with trying to clean up their ability to request information through subpoenas, a lot of it had to do with the providers not wanting to comply with the subpoena.
Okay. And my final questions, if I may, Mr. Chairman, just to make sure that I understand how this ties into your overall investigative role, which y'all do a great job with child porn and everything else. And I know that this is very important. It seems to me like this is probably going to be a first stage activity, and then you'll get information, then maybe issue subpoenas for actual search histories and things like that. Is that accurate?
So yes, this would be the starting block for trying to identify victims as well as potential bad guy actors in any of these crimes. The follow-on to that would be legal search warrants to move forward on other information as it relates to these cases. Exactly the same way we do those in the child exploitation cases.
Okay. And is our code good to go in terms of that stage of the investigation as well?
I believe it is at this point.
Okay. Thank you.
Yes, sir.
Any further questions? Number 27, Chairman
you.
Powell.
Deputy Commissioner Dutton, what is the definition, the parameters on the definition of cybercrime?
It's very broad. From the standpoint of a detailed description, what you're looking for, if I can defer to Steve Foster, my agent in charge, to provide that. Steve, you can.
Want to get at the podium?
Yes, sir. Basically, a cybercrime is a crime that's committed through the use of any type of digital device. So fraud that's committed using a cell phone, internet, fraud against a website, ransomware attacks. It's basically any crime that's used in the internet domain. And what we see are attacks on corporate websites, government websites, or attacks against the individual through their email service, through compromising an account that you may hold, and stealing your identity and then using your identity for illegal purposes. So it's basically any crime that uses that. For the purpose of this bill, it only applies to those crimes that are detailed under 16-9-93, which are the computer trespass, computer password disclosure, those specific crimes. But we investigate all crimes involving internet-based fraud.
So in a case where a certain fella I know on August the 19th, somebody, well, I don't know if they hacked into it, but they went into the DDS driver's license portals and unbeknownst changed the guy's address.
Yes, sir.
And for what purpose, they still don't know. Would that be a cybercrime?
Yes, sir. It would.
Other than the fact that they changed my address from Hartwell, Georgia to Decatur, Georgia, I thought that was a pretty serious crime.
Yes, sir. Yes, sir. And we'd like to speak with you. I would like to add the case that you just mentioned is an example of why we have this as our ask. Through our investigation, what is common is that we may have one victim that we become involved in an investigation, and it leads to multiple other identity theft victims whose addresses may be changed or other personal information. We don't have a jurisdictional or venue idea at the beginning of that investigation. We simply have a name and some basic information. This bill allows us to go through our own chain of command with a subpoena to gather more information about that victim so we know where they really are and we can contact them. So it allows us to be much more agile and aggressive as far as speed goes in finding out where our victims located.
At the proper time, I'd like to be recognized for a motion.
Okay, we've got several people signed up to speak. I'm going to hear from them first. Any more questions from committee members? Okay, Mr. Xavier Ash from Electronic Frontiers, Georgia. Just use the podium.
Will do. Good afternoon. Xavier Ash. I'm a Georgia resident here representing Electronic Frontiers, Georgia. I am a cybersecurity professional executive at a Atlanta-based bank. And just wanted to quickly summarize some of the concerns that we had brought up previously. Overall, we are looking forward to having the GBI join into cybersecurity fight. I think this is a great direction to go. The law the bill as it's proposed today, we definitely have some concerns as it's well not defined and in impacting the civil liberties of our citizens here in Georgia. The jurisdictional issues and to notifications that we've already discussed is highlight some of our concerns, and making sure that the privacy of our citizens is upheld through our legal process. On that, just wanted to otherwise give that summary and thank you guys for your work.
Do we have any questions for Mr. Ash? Number 14.
Are you going to tell us your concerns?
One of the things is that as a cybersecurity professional, I do know where my expertise is and where my expertise is not. And a lot of the concerns here, I think, it comes along lines in the ways that these warrants will be delivered to companies in the state of Georgia, and whether or not there are appropriate oversight and the ability to give the GBI the capabilities they do to do the investigation, but not overly impact the civil liberties of our constituents here in Georgia.
So, do you have any recommendations specifically
Not
to amend the
specifically
bill?
at this time.
No?
No.
Okay.
Any other questions? Okay, thank you, sir. Next, we have Jacob Essa from Capital Affairs.
Thank you, Mr. Chairman, members of the committee. My name is Jacob Issa. I work at the Capital Affairs law firm. I want to start by thanking the sponsor of this bill. We've been working with him along with the GBI and the Defense Lawyers Association over the past few weeks to try to better this bill. I do not have the current LC number in front of me. I have the previous version, which was 2421S. So my understanding is that some of our amendments have been included, but one has not. To my understanding, from starting on line 70, our amendment to reference Code Section 16-9-92 with regard to the definitions of electronic communication service and remote communication service is in the bill. I'm not sure if it is, but and the GBI was amenable to that clearly. Where I think our issue, where we depart, is with regard to the burden of proof required to obtain these subpoenas and to issue these subpoenas. So with regard to case law, in line 46, what we had proposed, and I have copies that I can give you of our proposed amendment, is to continue the sentence and require that, first of all, in compliance with Supreme Court precedent from 2019 in the Carpenter case, historic cell site location information be excluded from what can be obtained. This information is information that your cell phone, it might ping against a tower. Over time, agencies have previously used subpoenas to acquire your location over a certain amount of time. What the Supreme Court said was that in order to do that, you have to get a warrant. From what I understand, the emails that I've been copied on, the GBI agrees, but they don't agree that the language needs to be included. Our position is that it needs to be included that historic cell site location information be excluded from what the subpoena can get for it to be constitutional and comply with the Fourth Amendment. Along with that, and continuing on that line, we have recommended that there be a showing of specific inarticulable facts. There are a number of Supreme Court cases that say that agencies may issue subpoenas, but that their authority to do so is limited by specific inarticulable facts showing relevancy to an ongoing investigation. This showing does not have to be made until somebody challenges the subpoena, right, saying that they have a lawful reason to challenge it. Once it's challenged, we believe that the applicable authority is for GBI to have to go to court and show those specific and articulable facts with regard to relevancy. This is the language that we understand the GBI is not willing to include, but we believe must be in the bill for it to be held constitutional. Otherwise, if challenged, we think it would be overturned and held to be a Fourth Amendment violation. So again, I have copies of this language in here that I can give to y'all in our proposed amendments. Just to highlight on Representative Holcomb's statement earlier, we do think it would also be difficult, and this is something that we haven't talked about previously, but we think it would be difficult for somebody to challenge this since it's the provider who is going to be issued the subpoena. So if you are not being issued the subpoena for your records, it is hard for you to challenge it in order to say that this is a violation of our Fourth Amendment rights. So simply put, our recommendation is to include a requirement of a showing of specific and articulable facts with regard to relevancy to an ongoing investigation should the subpoena be challenged. Otherwise, if the law is challenged, it'll be overturned and held unconstitutional.
Could you provide the young lady with some copies so she can distribute them? We have any other questions from the committee? Number 15.
Thank you, Mr. Chairman. I want to dig into that a little bit more, and thank you for your perspective. I don't see, of course, you don't have the latest draft, but I don't see anything regarding the pinging data that this would allow the GBI to get.
To answer your question, I agree with you. I think that it is a gray area, and here's what I will point to with regard to the historic cell site location information that it could be grabbed in, but we don't know. It's not specifically enumerated, but on lines 52 and 55, under subsection 35-3-4.5B, it's B3 and 5, the local and long-distance telephone connection records or records of session times and durations. We think historical cell site location information could be grabbed up in that inadvertently, as well as with regard to number 5, telephone or instrument number of other subscriber number or identity, including any temporary assigned network address. If there are multiple, for example, pings or locations caught up in that to where it shows a picture over time, it could be a violation. Again, I agree with you that it does not explicitly say that it can be grabbed, but we think it could inadvertently be grabbed and create a violation. And always with lawyers, as many of you I'm sure know, it is better to be very specific rather than to create a gray area. And so our proposal is just to be very specific and to say that these subpoenas specifically exclude historical cell site location information.
Okay.
And that case is Carpenter versus United States. It says that it was decided in 2019 by the U.S. Supreme Court.
Were those Fourth Amendment issues that it was dealing with?
Yes.
Okay.
But again, we have no desire to make the GBI's life difficult. Our only desire here is to ensure that if this becomes law, it is not overturned if it's challenged. And that's what specific and inarticulable facts of relevancy being included and barring historic cell site location information will do, is ensure that this law cannot be overturned.
And if you indulge me just a little bit more, you did make reference to the questions that I was raising in terms of who would be the party to object. I am not an expert in it, but I do have some understanding of how it works at the federal level, and my understanding is that usually they're focused more on the intelligence side and less on the criminal side, and so because of that, an individual whose whatever records are being solicited doesn't know about it, and they just move forward without those issues, which I think in this context it almost exclusively is going to be on the criminal side. So with that, the issues that you're raising do spark my interest, because I agree with you that we want to make sure that there's no what is it, the fruit of the something tree that I remember from a long time ago. Poisonous tree. Yeah, thank you. And so with that, recognizing that you've highlighted to us some U.S. Supreme Court cases, do you have the same concern if this were to go through the state courts as a statute that it might face the same jeopardy?
Yes, and the reason why, the U.S. Supreme Court cases mostly are in regard to federal agencies. However, state agencies and states are still subject to the Constitution as federal agencies are, and it's the same general line of thinking. Now, to be very specific in lines, for example, 59 through 61, where it says the provider does or shall not provide notification of the subpoena to the individual, the reason that is constitutional. We don't think it's great, but it's definitely constitutional. And the reason it is because the Supreme Court has said if you voluntarily give your information to a third party, right, which is the cell phone provider, the provider in general, then you don't have a reasonable right to privacy. You don't believe that you have a reasonable right to privacy over that because you're giving it to somebody, so the government can get it as well. However, we do think that if you do not include a burden, a standard of proof, right, which is specific and articulable facts of relevancy to an ongoing investigation, that they have to just show on the back end, once it gets challenged, if it's challenged by the provider, or even if somehow the individual does become aware of it, that it will be overturned because it is an infringement on their Fourth Amendment rights, especially in a criminal proceeding.
Okay. I'd be curious to hear a response from GBI on that if they have one.
Well, they want to speak, so go ahead.
I'll just, by way of background before we get into that, this bill was dropped just after crossover day last year. It's been out there this whole time. When we scheduled the bill about 2 weeks ago is when conversation started happening.
Yeah.
I thought that everyone was on the same page in regard to this until about 2 weeks ago, and then we had some conversations with a number of different groups, many of whom have spoken here today, to try to get everybody in agreement with what we were trying to do here. Basically, we have just within the past couple of days have had two requests relative to amendments, one of which has been incorporated into the LC 41-244-2S, which you have in front of you. The other one, which you were having discussions about with the presenter, was considered by the GBI. They have been involved in this process the entire time. I've tried to keep everybody in the loop, keeping everybody communicating with each other, even through legislative council, to make sure everybody understood what was going on and had the opportunity to weigh in. As I said, the GBI had all of this information. I have had conversations with them, and they have chosen to go with the draft that we have in front of you, weighing what had already been discussed, what you had discussed, and that was their decision. I'm not the lawyer. I cannot give you the legal issues surrounding that. I'm going to, with the chairman's permission, I'm going to let the deputy director address those issues, but I wanted to give you a little context about what has been taking place in regard to how this has unfolded, okay?
Yeah.
Okay. Thank you, sir. With regard to specific and articulable facts in any kind of case that we're working where we request a subpoena, that does exist. So there is paperwork at headquarters in that particular unit. And there again, I'm referring back to our child exploitation squad, because that is what they do. There is a registry, a list of all of the subpoenas, the crime that we're looking for, the specifics of how they got their tip, what leads to a reasonable person to believe that there's criminal activity afoot, and that exists within our files. So if anything, and when things are challenged, that does exist from that standpoint. And we've operated from the standpoint that if needed, we would provide that.
So do you have a problem putting it into the statute if you're doing it?
Well, so it goes back to, from the standpoint of, I see this as a very specific area of concern, and I recognize why it is a specific area of concern. However, since day one, I think most law enforcement recognize this requires a search warrant to do this. We don't, I mean, it clearly states what we would get through a subpoena. If we need search warrants, we get search warrants. It's kind of apples and oranges in my view as to how it looks to telling us what you cannot do. Obviously, you don't get detailed call information, so you're not listening to phone calls. Everybody recognizes that requires a warrant. These are subpoenas.
Okay. Yeah. However helpful this is I'm generally supportive, and I think the categories of information that are being requested don't infringe mightily on one's privacy, because it's not the actual transcripts of phone calls or anything like that. It seems to me like this would probably be in the initial stages of an investigation, as I mentioned earlier, as opposed to down the road. And the other thing is that it does require consent of the Attorney General or the prosecuting attorney to issue the subpoena. So there is a requirement there of some collaboration. And I would think that the Attorney General and the DA would be working through the probable cause issues, and if they thought that there were going to be any challenges based on right of privacy, Fourth Amendment, et cetera, that they wouldn't issue a subpoena otherwise. So those are just my initial thoughts, but I really appreciate the feedback.
Thank you.
If I may just say this, we are very appreciative of the chairman. He's been very accommodating to us and worked with us greatly, and we're very appreciative of that, and I want that to be known. But yes, our concerns do just still stand there with regard to the burden of proof.
Got it.
Did you have a question, Ms. Evans? Anybody else for this speaker? Okay. We've got one more person on the signage. Maisie Lynn Causey from the Georgia Association of Criminal Defense Lawyers.
Yes, sir. Thank you for hearing from us today. And I would just want to reiterate my colleagues' thankfulness to the chairman, to the GBI. This has been a collaborative process over the past few weeks. We appreciate you considering. I stand with Mr. Issa. We have the same concerns. I won't belabor the points, but just want you to know he doesn't stand alone. There are other organizations who bring these same concerns to the table, and we are among them. Thank you.
Any questions? Okay. I think we're at that point in time. We have a motion to pass.
I'd like to make an amendment, offer 2 amendments. Is that appropriate now?
Okay, we have to wait until we get to the comment section.
Okay.
Okay, we have a motion to pass. Do we have a second? Second. Okay, now would be the proper time if you wish to make a motion for an amendment.
I'd like to make the amendments to HB 641, LC 412421S, supported by the SPLC and the GPDC. And I'd like to make these offer these 2 amendments. Do I need to read them out loud, or? Okay.
I think it would be good, but I think we.
The LC number that was mentioned is a different version than what we're working on.
Excuse me, yeah, you're right. Yeah, I need to make it to that 2422S. Is that right?
2442S.
Yeah. Right. 2442S. Yeah.
Okay, and I think we need to make the amendments one at a time since they say different things. So we have a motion to make an amendment number 1 to, and I'll read it, placing line 46 with the following: of the communication and historic cell site location information upon a showing of specific and articulable facts of relevancy to an ongoing investigation to the Superior Court having jurisdiction for such an order. The subpoena shall state such specific and articulable facts of relevancy to an ongoing investigation. Do we have a second? We do not have a second, so the motion dies. You want to go to number 2?
No, actually, I think it's already been done.
I would
Okay.
like, yes.
Okay.
Number 2 has already been incorporated.
Okay, we've got a motion do pass and a second. If there are no further questions or amendments, all in favor signify by saying aye. All opposed? Motion carries.
Thank you.
And we are adjourned. Thanks for everybody's contributions today. I wonder what happened on these other